It's amazing that it becomes quiet right at 7:30. It's like, get up here, let's start. So I'm going to start. Welcome everyone in person and online. Thank you so much for being here. My name is Ty Sidgley. I'm the David H. and Ann L. Hinchcliffe Professor of History and the Executive Director of the Common Ground Program for Active Citizenship. We'd like to welcome our guests, Mike Reigel, Bob Bauer, and Jack Goldsmith. Especially great to see you, Jack. We were college classmates and saw each other a very, very, very long time ago. So Common Ground's mission is to promote civil discourse on tough issues to prepare students for active citizenship. Common Ground works to create opportunities for our community to have respectful, honest conversations, and in a variety of ways. So let me give a plug for a few upcoming events. Tonight's event will provide us with several follow-up opportunities to talk about the weaponized presidency. So tomorrow, Tuesday, 4 November at 12, in Levitt Center, we'll have a post-event dialogue catered by Rio Grande. I think that's how you pronounce that. On Wednesday, 5 November at 12 p.m. in the events barn, we'll have Common Ground continued with government professors Rob Martin and Annabelle Hutchinson, and of course, lunch provided. And in a new initiative on 10 November, 7 p.m. in the events barn, our Common Ground ambassadors, raise your hand, ambassadors. Where are? Back here, well done, okay, in the back, counting. We'll host a political speed dating event. So check out our newsletter, brand new, on Common Ground that our ambassadors just came up with that'll be around campus. And so thank you to them and thank you to the Common Ground team, Katie Stewart and Kim Ritchie. So looking to next term, in February, we will address the 5th anniversary of the political violence on January 6, 2021, with former Representatives Democrat and Hamilton alum Matt Cartwright and Republican Tom Rice. We have this program because of the support of our leaders, our faculty, our alumni, and our friends. The college is especially grateful to Mary Helen and Rob Morris, David and Lori Hess, Eve Niquette and Charles Poole, the Warning family, and the Pooley family. Their support is indispensable. So let me introduce our moderator, and he will introduce our guests. Mike Reigel is a 1979 graduate of Hamilton and the parent of a 2023 Hamilton grad. He is the co-chair of the international law firm Greenberg Traurig, their media and entertainment litigation practice group, where he specializes in First Amendment issues. Mike has an adjunct faculty appointment at Cornell Law School, where he teaches in the First Amendment Clinic. Thanks, Mike, and the floor is yours.
Thank you, Ty. I appreciate the introduction. And thanks to everyone for coming tonight. I'm sure we'll have a really interesting and entertaining and informative program for you. This is the third time I've been privileged to moderate a Common Ground program. During the first two events, there was absolutely no common ground that was found, for better or worse. I don't think that's going to be the case tonight. I think there will be some areas of convergence and agreement, although I expect some disagreements will surface as well. When Ty first asked me if I was interested in moderating this program, I leaped at the opportunity in a nanosecond because the panelists we have here are just so remarkably accomplished and well known in the professional space that I happen to occupy. They have impeccable records of government service in the legal profession and also in the legal academy. So Jack Goldsmith is the learned hand professor of law at Harvard Law School, a non-resident senior fellow at the American Enterprise Institute, and co-founder of Lawfare. He teaches and writes about presidential power, national security law, federal courts, conflict of laws, international law, and internet law. Before coming to Harvard, Professor Goldsmith served as Assistant Attorney General, Office of Legal Counsel in the early 2000s, and Special Counsel to the Department of Defense from 2002 to 2003. He was a professor at the University of Chicago Law School from 1997 to 2002, and at the University of Virginia Law School from 1994 to 1997. Before entering the Legal Academy, Professor Goldsmith was an associate at Covington & Burling, a large firm in Washington, D.C., and he also clerked for Supreme Court Justice Anthony M. Kennedy from 1990 to 91, for Court of Appeals Judge Harvey Wilkinson from 89 to 90, and Judge George Aldrich on the Iran U.S. Claims Tribunal from 1991 to 1992. Professor Goldsmith received a BA from Washington and Lee University, where he was a fraternity brother of Professor Sedgley, and a BA and MA from Oxford University, and a JD from Yale Law School. Bob Bauer is Professor of Practice and Distinguished Scholar in Residence at the New York University School of Law. Bob was General Counsel to President Obama's 2008 and 2012 presidential election campaigns, and then served as White House Counsel to the President from 2009 to 2011. In 2020, he was a senior advisor while on leave from NYU to the Biden presidential campaign. In 2013, President Obama named Bob to be co-chair of the Presidential Commission on Election Administration. We may talk a little bit about that tonight. In 2021, President Biden named him to be co-chair of the Presidential Commission on the Supreme Court of the United States. In 2024, Bob was a recipient of the American Bar Association's Unsung Heroes of American Democracy Award. So please join me in welcoming our panelists tonight. So I thought it might be a productive place to start. We've heard much about this concept known, Jack and Bob, as the unitary executive theory. And it's even percolated news coverage about some of the current endeavors undertaken by the Trump administration, but I'm not sure many of us have a really clear understanding of what that term actually means. So to me, and you may disagree with this, but to my knowledge, the most clear and forceful articulation of that theory was in Trump versus United States, the presidential immunity case. But I thought it might be helpful to begin to frame the discussion by explaining what that constitutional theory refers to. So Jack, if you want to start, and then Bob, feel free to weigh in.
Sure. So thank you so much for coming tonight, and thank you for having us. The unitary executive begins with the first sentence of Article 2 of the Constitution, which says, "The executive power shall be vested in a President of the United States." And as Justice Scalia said in one opinion, and as it's been repeated by other justices since, when it says the executive power is vested in the President, it's the executive power, comma, all of it is vested in the President. And that's the basic idea of the unitary executive. The idea is that unlike the legislature, where it's all powers herein granted are vested in, all powers granted here are vested in this Congress, this multilateral body, that all executive powers is vested in this president. And what that means essentially is that every person in the executive branch, on this theory is what it means, every person in the executive branch has to be exercising the executive power, i.e. the president's power. And that means that the president must have the authority to direct and control every single person in the executive branch. And, depending on how robust the theory is articulated, the power to fire everyone in the executive branch. Now, the Supreme Court has never gone, so the idea is the president has complete vertical control over the executive branch, can order actions as he wishes, can interpret law for the executive branch, and can fire people in the executive branch. That's the pure theory. The Supreme Court has never gone quite that far, but it's been moving in that direction. And that is a theory, as you said, that Trump versus United States robustly reaffirmed. And that is a theory, and we can talk about this if you want, but I'll stop here. That's the theory that President Trump is relying on quite a lot right now to fire officials, to order officials in the executive branch to do things, and basically to assert unprecedented control over the executive branch.
No, I think that's a really helpful explanation as a starting point. Bob, anything you care to add to what Jack has said? And he did mention I think a vertical dimension to this, but I would also submit there's a horizontal component to this, and separation of powers issues that naturally get implicated when you have a very broad assertion of executive authority pursuant to Article 2.
Yes, I mean, Jack has very succinctly and well described what the theory is. the one point I want to make is that for years it was debated, it goes back a long way before Donald Trump, and very much associated with a conservative Republican view of executive authority. I think it's fair to say probably received the most attention, Jack, during the George W. Bush administration.
Well, also during the Reagan administration.
During the Reagan administration. And yet, I think it's important, and we can discuss this further as we go along, there is something quite unique about the direction in which Donald Trump took it, which has taken it and continues to take it, which I think distinguishes it from its conservative root, if you will. There are many ways in which he's doing this that I think conservatives in the older tradition, the longstanding tradition, would not be comfortable. And the only other point I would make is that it has been developed in such a way, that is to say this administration has pushed it and promoted it in such a way that all of a sudden the Supreme Court is faced with the question of, wait a minute, is this precisely how we should read this theory? Are the practical implications now becoming clear in a way that they didn't before? And you can see this just as the only example I'll give at the moment. There are other examples in the case that involves the Trump administration's firing of a member of the Federal Reserve Board, governor of the Federal Reserve Board, Lisa Cook. And the court has not resolved that case yet, but in a preliminary order, the court indicated that it was somewhat uneasy with the idea that even if the president could control agencies, just as a theoretical matter, well, maybe not the Fed. Maybe there's something about the Fed that's different. And there's some other examples where I think the theory is bumping up against its practical application that I think is worth noting.
May I just say one thing about separation of powers? So I agree with you that it has a separation of powers component. When I said the president asserts complete vertical control over the executive branch, what that means in practice, as Bob was suggesting in these firings, is that the president is disregarding congressional statutes that purport to organize the executive branch, that purports to say who the president can fire, that purports to say how the offices shall be organized. So when the president asserts this extraordinary vertical control, he at the same time is often disregarding statutes and therefore basically ignoring or claiming dominion over what Congress has tried to do.
Okay, and that was really the point I was driving at, Jack, which thanks for picking up on it. The first title on the program tonight is the weaponization of the presidency past. So looking at it from a historical perspective, and I do think, and certainly we'll come to this, most observers reasonably view the Trump administration as aggressively developing this theory, perhaps where it's ever been before. In fact, I think, Jack, you recently characterized this as the Trump administration engaging in the moonshot of executive authority. So there may be some agreement between you and Bob on that point. But in addition to President George W. Bush's very expansive assertion of presidential authority for national security justifications after 9/11. Are there other historical antecedents that can help inform our understanding of this doctrine? And maybe there is some history of an escalation of power grabs by the executive branch, so this isn't something entirely new under the sun.
You want me to start with that?
Yep.
So let me define weaponization first, and it's actually hard to define. But I think of weaponization as the idea that the president is using all the tools of government to try, with the intent of trying to harm, destroy, or degrade a perceived enemy. It can be a political enemy, it can be a civil society enemy, it can be an enemy within government. And defined like that, Trump is not the first president by a long shot to weaponize the government. I've been studying this a bit. You can go back to the Alien and Sedition Acts, which were these laws in the 1790s that made it illegal to criticize the government, and they were actually hugely controversial. These prosecutions were widely seen as the government inappropriately using the tools of government they were going after basically members of the press of the opposite party. And they did not use the word weaponization, but it was basically the same basic idea, that they were using the tools of government unfairly to try to degrade a perceived political opponent. Some people think that, well, I'll skip the some people think that Thomas Jefferson's efforts in which he was heavily involved in ensuring that Aaron Burr was prosecuted was an example of weaponization. But it really got going in the 20th century as the state grew. Franklin Roosevelt engaged in what we would today call weaponization. He used the Federal Bureau of Investigation to investigate his political enemies. He engaged in, had his Justice Department investigate political enemies, and he, those are the two main things he did. The use of the IRS was also something that to harass and intimidate political enemies was something Roosevelt did, subsequent presidents did. Of course, Richard Nixon had the famous enemies list. John Dean, his White House counsel, wrote the famous memo in which the first paragraph said, and forgive me, but I'm just paraphrasing what he said. He said, this memo is about how we can use the tools of government to bring us political advantage. In other words, how we can do our best to screw our enemies, and that's almost a quote. And they started off on that effort, and then it didn't come to much. Some people think, and weaponization is a term that started being used in the 2010s. So there was a prehistory to this. Some people have alleged that the Biden administration's use of the Justice Department to prosecute his political enemy, the current president, was an example of weaponization. But having said all of that, and there was basic rise of this as the state rose and got more powerful, there's nothing that can compare to the way the current president is using these tools. So these were all precursors. It didn't start with Trump, but he has perfected it and used it in a way that no president before imagined.
Okay, so we have these historical examples of an aggressive assertion of presidential authority under Article 2. Bob, do you agree with Jack that President Trump is taking this to a previously on a level that we haven't seen before at any point in our nation's history?
Yes. I mean, I don't think it's any, I mean, to me, there really isn't any question about it. There are, as Jack correctly said, all sorts of examples of the abuse of government power to intimidate or cow opposition. One that came to mind I hadn't thought about earlier today, Jack, when we were in classes, was John Kennedy's threats, including use of the IRS, to cow the steel industry into rolling back what he thought was both an inflationary price increase, but also the violation of a commitment that they had made to him, he thought, not to in fact raise prices. And he was quoted as saying to somebody, this is what happens when you cross the presidency of the United States. So there was latent in the ever increased power of the presidency, and we might want to talk about what is driving that development in our political system, but there has always been latent in it the potential for abuse, and there are examples of abuse, but I think it would be impossible for someone to argue that the systematic, programmatic, unapologetic use of weaponization in the Trump administration has any precedent before it.
Okay, well, I'm happy to hear both of your views on what is driving this, so please feel free to elaborate.
Well, I shouldn't have invited the question because it's a complicated one, so I'm just going to take a piece of it and then turn it back over to Jack for his thoughts. In the book that Jack and I wrote together on reform of the presidency, every single chapter that we wrote on any number of topics, pardon power, financial conflicts of interest, war power, control of nuclear weaponry, every one of them attempts to show, before we get to Donald Trump and before we get to the reforms that we think need to be considered in relation to the presidency, every one of those chapters begins by showing at least some meaningful increase, and in some cases dangerous increase, in presidential power over time, claimed by presidents of both parties. One factor driving it is that we have in this country, as a matter of political culture, an outsized expectation of what presidents are supposed to do. The one office holder who's elected by everybody in the country on typically vast promises of being able to transform the lives of citizens, not to mention bring peace throughout the entire world. And the people who seek that office come with enormous expectations plus enormous ambitions, and are going to look, not necessarily in every case illegally or unethically, but look for every opportunity to enhance the powers that are available to them to do the things they believe they were elected to do or that they promised to do. And this is a key point, that the public expects them to do. And there's a peril there, because if they don't produce what the public expects them to produce, there's a danger that they'll slide into public disrepute and potentially not win re-election. But that expectation is there, and presidents recognize it, and they don't tolerate an awful lot in the way of opposition they think they can overcome. And I think we just have to recognize that there's a distortion in our system of government that at least begins, in my view, with the outsized expectation of the presidency. And very quickly, quick anecdote. President Obama's first inauguration, I attended it. I'd represented him during the campaign. I later went to work for him. And all of a sudden I was struck. It was, of course, an extraordinary inauguration. There were hundreds of thousands of people there. I don't want to get into an argument about crowd sizes here. But
This is the largest crowd that's ever been assembled in the Hamilton Chapel, just for the record.
I see 5,000 people here. But before President Obama came out on the stage, 2 trumpeters came out and blew trumpets. And I thought, one is put in mind of, the angel Gabriel making an appearance. And I was an Obama supporter. And I thought there's something wrong with this entire ceremony and this entire setup, just from the standpoint of what we expect and how we think about the presidency.
So Jack, do you care to add to that? I mean, I think Bob
Sure.
is absolutely right. There are some structural forces in play here that naturally almost induce centripetal pressure to have this result. So let me have your thoughts on the point.
I don't disagree with that. I don't think the centripetal pressure, President Obama did not weaponize the presidency against his enemies. And the centripetal pressure, I believe, is about presidents needing to get things done, having to push the bounds. There's no doubt about that. I think there are a variety of factors that have led us to where we are today. It's overdetermined. One is President Trump is a populist, and in my view, a populist demagogue, and that means that to him, any institutions that stand in the way of his power are threats that he wants to try to neutralize. This is the populist program, is to eliminate institutions that are checks on power, or I should say the populist demagogue program. So one way to do that is to try to weaponize government to do those things. President Trump wanted to do this his first term. He did not have, for him, the right group of people in power. He learned from that lesson. While he was out of power, they spent 4 years studying what went wrong, why they had the wrong people, why they weren't able to accomplish the kind of norm-breaking and what I would view as weaponizing aims of the first term. So they have a much better game plan now. They have much better people in place. Also, this has gone hand in hand with the growing splinterization or divisiveness or rivenness of our society, where, and this is something that's happened in politics in Washington that transcends the presidency, with norms in general being diminished, with every political constituency trying to get as much as they can in this round, in which there's no thought about the future, no thought about the next round. Then on top of that, I think that there's been a somewhat of a tit for tat that's been developing over the last 10 years. Certainly, Biden supporters don't appreciate the extent to which what I view as lawfare against the Trump people and Donald Trump himself. I'm not saying all of these prosecutions weren't justified, but there was an institutionalized effort to use law in very aggressive ways, including by the Biden administration, in norm-breaking ways to try to basically take out the president, who was President Biden's opponent. That was, whatever you think about that characterization, that's the way it was perceived by the Trump people. So I think there's a large tit-for-tat element here. And the last thing I would say is the Trump administration has, as an ambition, it really feels like, and this is based on talking to a lot of people in the administration, and it's not a secret really. They're not hiding it. They feel very strongly this is one chance they have to neutralize what they see as progressive dominance of certain institutions, the universities, the deep state, the media, major law firms being four of them. And basically, as far as they're concerned, those ends of neutralizing those institutions justify basically any means. So I think that's my combination of explanations for why we are where we are today.
That explanation, I think, is uncannily accurate. It also makes me very uncomfortable because I have associations with three groups that you identified.
Universities, law firms, the media.
Exactly.
Yeah. You're under attack.
Sometimes it feels that way, but not always. I'm here to fight the good fight. Do you want to add anything to that, Bob, before I move on?
No, I mean, I do want to make it clear. My point about the presidency certainly wasn't to suggest that every president who comes out to this huge hoopla is done what Donald Trump has done and perfected weaponization of the program. I'm not suggesting that at all. I certainly wasn't a witness to anything in the government that I served in. But I do think that as power accumulates and as the expectation of the use of power intensifies, the risk of weaponization goes up. And then when you get, as Jack correctly described him, a populist demagogue who, by the way, doesn't have much experience in government, doesn't appreciate or particularly care for the norms that have by and large been observed by presidents, then you wind up on the road to what we are seeing now.
Okay. So let's work through some current examples on the political and legal landscape that may help concretize this idea of the unitary executive theory. And of course, one of the criticisms being frequently levied against the Trump administration is the politicization of the Department of Justice. I do hear people on the right sometimes say, well, this happened with the Biden administration. I'd be interested to hear your rejoinder to that, Bob. I know my role here tonight is as objective interlocutor, but I simply do not see the same things happening with the Biden administration and the aggressive targeting and what I would characterize as persecution of political enemies. The James Comey indictment. Is there any credible basis in law for that, Jack?
Not in my judgment, no.
Okay. Bob? All right. Easy point of agreement. We have common ground there. Should President Trump have been prosecuted for his role in the events that unfolded on January 6th?
So my view at the time, and I think I've been vindicated by events, was that it was a prosecution that met the standards for prosecution in the Department of Justice, which means, do you think you've got a chance more likely than not of securing a conviction? But I thought it was deeply imprudent at the time because I knew and said that the legal theory on which it was based, obstruction of a congressional proceeding, was a very controversial interpretation of the statute that the Supreme Court ended up disagreeing with later. I knew that there were going to be massive problems about presidential immunity. I argued and believed that it would result, no matter what happened, in significant additional politicization of the Justice Department, no matter how neutral they thought they were being. When you use the Justice Department to prosecute the president's opponent, that can't help but be viewed as massively political, coming in the context of many other criminal investigations around the country that were Democrat-led and were perceived that way. There's just no chance that could have been perceived as anything other than deeply political. And I also believe that you don't. So I was perfectly okay and supportive of the indictment and prosecution of the other Justice Department indictment concerning the classified documents. That was a clear case of clear legal violation. I think the Justice Department had no choice but to go forward there. But my strong view is that you don't go after your political opponent, your former political opponent and your future political opponent. Talk about norm violation that's never happened before, unless you have a very above-the-bar, clear case for conviction, and that clearly didn't happen, and I worried that there would be all sorts of adverse consequences, and there were, and we're living with them now.
So I'm interested to hear your take on this, Bob, but it sounds like there's two avoid explanations there, Jack. There are important prudential considerations dealing with making sure that we avoid politicization of the DOJ to the extent we can and going after political adversaries. But if I heard you correctly, you thought that the prosecution based on the January 6th involvement was more questionably or more novel legally than the classified documents.
Much more so.
So were you okay with
Yeah.
the prosecution under the
Yes, I
classified
said so.
documents?
Yes, I was.
Okay.
This is a point on which Jack and I do disagree. I do agree that there were, and I want to be generous about it because these are really tricky issues that had to be handled, there were significant failures of execution in the prosecution of the president at the federal level. I do want to distinguish what the Biden administration can be responsible for, which is not the state level prosecutions that were brought in New York and in Georgia. They were controversial for different reasons. Granted, I totally agree with Jack. One of the risks that you run is the public sees them all the same. They're all Democratic prosecutions of the former president. And that did significantly complicate the way the Biden administration's motives in the federal prosecution were perceived. I do not see how we can have a norm that, except in the absolute clearest slam dunk cases, a president or a former president who, while in office, engaged in what was extraordinary conduct that certainly raised criminal questions, should not be investigated, and where good judgments are made about prosecution, later prosecuted. I'm just troubled by that. I understand the concerns, and I think they're grave, grave concerns. But I really do see it more as a failure of execution than a failure in concept. I wouldn't want a norm that gives the President of the United States, a former President of the United States, that level of protection, both a protection at law under immunity and also protection by norm, as in, well, we don't do that sort of thing because it's dangerous unless we have a completely slam dunk, clear, we know that he or she did it, violation. I think that ultimately weakens confidence in the system of justice. I think it also contributes to presidents' feelings of invincibility, which is already bad enough as it is. And I think that's, we can talk about all the different ways that presidents can protect themselves. And it's not only by immunity, it's by the use of the pardon power. There are other ways that they can do it. So I am also troubled by the course of events, but as I said, I won't go so far as to endorse the norm that Jack articulated. And this is the one area in which we had a back and forth of disagreement in the book that we wrote together on the reform of the presidency.
Can I say one thing?
Sure.
Just to be clear, I was responding to the question whether the January 6th prosecution was justified, and I think it clearly wasn't. I think that was true before and after. Nothing I said in any way justifies what President Trump is doing now. It wasn't, because even if I'm completely right about what I said, what he's doing is not justified.
Let me ask a loaded question to both of you. Did the United States Supreme Court slow walk the immunity decision?
To the contrary, Jack Smith sped up the prosecution, in my view, in clear violation of DOJ norms. There was no justification. He kept saying there was a public interest that the court go fast. He could never explain what that public interest was. The court did not only not slow walk it, it granted certiorari and put it on a relatively short track. I think that was a mistake because I think that short track and giving in to the pressure that Smith was putting on them to go fast, which I think was inappropriate, led them to make a highly imprudent decision. So I don't think they slow walked at all. There's no evidence of that.
Okay. Bob, what's your take on that question?
I don't disagree. With Jack that while I have quarrels with the way the Supreme Court ultimately resolved the immunity issues, and by the way, also think there's a lot of characterizations of what they did by critics are overwrought, I also do not believe that the slow walking charge is on the money. I don't think that's correct. Look, the court is faced and has been faced, not the only time in its history, but with an intensity and a bombardment almost with extraordinarily difficult decisions that it has to make. Mm-hmm. And its own credibility, its own legitimacy is at stake. Some of these are really hard legal issues. So, I would not put the blame on the court in that circumstance. And I also agree that if Jack Smith wanted to expedite this case, then I do think he owed an explanation, as Jack said. And I don't think the explanation he gave was either, that he ever did it, or that to the extent that he implied one, that it was particularly convincing. And I think it added to the impression, not to President Biden's benefit, that the Biden administration was gunning for Donald Trump.
Exactly.
Okay. Another example. My understanding is, correct me if my facts are off on this, but with the current government shutdown, Congress had allocated $8 billion to a research and development line item in the Pentagon's budget. And President Trump wanted to make sure that the soldiers got paid and the U.S. military forces were paid during the shutdown. Politically, that is something that is a very popular choice, very difficult to disagree with. So my understanding is that President Trump transferred the money from that congressionally authorized fund to use it for a different purpose. Is that acceptable under any theory of government? If that's the case, why do we have a Congress?
So I don't know the details of this. I would have to look at the statute that he relied on. There's lots of statutes that allow certain appropriations to be repurposed for other appropriations, and I would just have to know a lot more to know if it was lawful. I mean, I can't, just to give you an example, I think probably wasn't lawful. If it's true that this donor gave $130 million to pay for the troops, I think that was pretty clearly unlawful under the Anti-Deficiency Act. But on that statute, I just don't know. I wouldn't be surprised because they've been playing fast and loose with appropriations law, but I just don't know about that case.
Okay. Anything you want to answer that, Pat?
I'm with Jack. I don't have a view. I have not studied that issue. I was going to go exactly where Jack ultimately went, which is to add insult to apparent injury if there was a legal problem. The idea that the tab would be picked up by a wealthy ally of Trump is on so many different dimensions problematic. Legally, governmentally, by any sort of measure of democratic ethics and practice, astonishing.
Yeah, I think we can all agree on that point, but the larger issue here too is, hasn't part of what's going on been enabled by a Congress that is worse than quiescent? It's actually supine. And do you think for some reason that the current congressional inactivity has also enabled this expansive assertion of executive authority?
Do you want me to take that? You want to take that?
Sure. There's no question Congress is exhibiting very little institutional self-awareness or placing much in the way of emphasis on its institutional responsibilities. It is the majority in the Congress is operating as an adjunct to the president's party and as an ally of the president, and that is driving first and foremost its response to virtually everything. Let me give you one example that, and this is consistent with the view that we're bombarded with so many things that something particularly astonishing happens and then you lose sight of it because 10 more astonishing things happen before the end of the week. So you can't track them all. A member of Congress from Arizona, recently elected with 71% of the vote to an open seat, has still not been sworn in. The speaker won't swear her in. So she can't take her seat. She can't represent the constituents in her district. Why? Because the Republicans are concerned that she supplies the 218th vote for a House demand that the Epstein files be released. And she's already announced that she will provide that vote. So he won't swear her in. And that's clearly an attempt to aid the president in defending against something that he cares profoundly about and that he thinks will be politically and personally injurious to him. I'm obviously not a young man anymore. I go back, I've been in Washington, D.C. I was in Washington, D.C. for 40 plus years in my career. I've been through some rough partisan moments, represented the Democrats on Capitol Hill during the Gingrich speakership, which was a very divisive speakership in the early to mid-90s. I've never seen anything like that kind of breakdown in basic norms in the Congress. That would not have ever happened. There's some bad things that happened, for sure. But the notion that the Speaker of the House, at the direction of the President, does not swear in a duly elected member, and that's still the case. It's been weeks. Won't do it. on the grounds that quote, it's a scheduling issue. It takes 7 minutes to swear somebody in.
Can I add something to this?
Sure, certainly.
I just want to underscore something Bob said and give one more example. Bob said that the Congress was more under the control of the president, is beholden to the president and not the institution of the Congress. This was just a mistake or a failure of foresight by the founders. They believed that the members of Congress as an institution would have an institutional interest oppositional to the president, and that would be an important check to the president. And over time, especially due to the rise of parties, that has just diminished. And we're now living in an area of extreme partisan divisiveness. And basically, the Republicans in Congress have, not the first time this has happened, but it's an extreme version, have laid down to the president. I'll just give one example. And this is hugely important because the Congress is the institution, really, much more than the courts, in my view. They're supposed to do the heavy work of checking the president. And I'll just give you one example. There's no more important power that Congress has than the appropriations power. And Russ Vought, who's the head of OMB and one of the masterminds in the administration about basically everything they're doing with appropriations and with the administrative state, he's up for confirmation before the Senate Appropriations Committee, I guess it was. And Senator Collins, whom I admire, is the chair of this committee. Russ Vought had made extremely clear in the 4 years before he became this position that his goal was to destroy the congressional appropriations power. He didn't make any bones about it. He laid it all out. Everybody knew it was going to happen. He didn't back away from it in his testimony. And Senator Collins, who's the chair of this committee, voted for him. In other words, voted for someone whose institutional commitment was to destroying her committee's authority. And I'm paraphrasing now, but when she was later asked, why did she do that? She said, well, if they do something illegal, the courts will take care of it. This is not the attitude that the framers thought Congress would have. And it's just, and if Congress is not going to stand up for its institutional priorities, then the courts cannot save us.
Can I mention one other example? It may seem small, and everybody understands when they tune into congressional hearings that they're going to hear a lot more from the members of Congress than they're going to hear from the witnesses. The questions become the basis for, long, self-justifying speeches, politically attractive speeches. That's all part of the game, and it's not always attractive, but it's accepted on both sides of the aisle that it's their hearing and they're going to use it the way they want. Again, something I've never seen before, a parade of Trump administration witnesses have come before the committees, like recently Attorney General Bondi and FBI Director Patel, and responded to the heated questioning by flinging insults at the members. Just basically saying, it's like a sophomore year food fight. Yeah, well, you say that, but you're stupid. And the only reason I mention that is in the past, Democrats and Republicans would have actually together taken the position, you can't come before the Congress and deal with us that way. You just can't do that. You can't use that tone of voice. You can't take those tacks with us. Yeah, we may beat you up, but you've got to just find a way and grin and bear because we're the Congress. There wasn't a single Republican, to my knowledge, who criticized this behavior. Wouldn't do it because they would have been trolled or attacked or criticized by the president's supporters of being weak in his defense. These things do matter, and it's another indication of how far the Congress has fallen.
Mm-hmm. Yeah, I think any reasonable observer who saw Pam Bondi's testimony before that committee would say, whatever norms prevailed before this, they are now completely shattered.
Shot, totally shot.
Let's turn to a couple of other examples. One that has now crystallized in two different judicial opinions that are very recent and reached different outcomes. So this concerns the federalized deployment of the National Guard to what the president has characterized as the war-ravaged cities of Portland and Chicago. And just to set the stage a little bit, the Seventh Circuit Court of Appeals, federal court just below the U.S. Supreme Court, issued an opinion that was unanimous on October 16th, 2025. It's actually quite slender because there was quite a bit of unanimity between the court, and they had no trouble whatsoever striking that deployment of troops as unlawful and beyond the ability of the president to exercise his authority. 4 days later, October 20th, there's the Ninth Circuit, which governs Portland, Oregon. And this is a much longer opinion, 94 pages, more or less the same issue. And there is a dissent in this case. And the Seventh Circuit, as I said, struck down Trump's deployment of the National Guard to Chicago. The Ninth Circuit upheld it. So I don't want to get too technically weedy if we can avoid it, Bob and Jack, but I think it might be interesting for the students and the members of the public here to have an understanding of what is the legal hook, the authority that the administration is relying on as justification for doing this.
You want me to go? It's hard not to be technical, so I'm going to purposefully not be technical, but if there are any lawyers in the room, forgive me. So basically, they're relying on a statute that allows the president to federalize the National Guard. And the predicates for federalizing the National Guard are basically when the regular forces are not able to enforce the law. And there's now an interpretive dispute about what regular forces mean that I'll skip over. And then the president is using that justification to call them up, and then he's relying on his own constitutional powers to use the National Guard, not for law enforcement purposes, but to protect the ICE as they're enforcing the law. And so that's the basic issue, and the essential issues in these cases are, is there enough violence? Is the president really unable to use the regular forces to enforce the law? The problem with this law is, I mean, it seems, from a non-legal perspective, it seems entirely unjustified for the president to be federalizing the National Guard because the problems, the levels of violence, the levels of law enforcement breakdown seem not to warrant it. But the statute is so easy to satisfy, and the president gets deference on the question of whether the statute is satisfied. So the courts are struggling with the question, how severe must the inability to enforce the law be? How violent must things be, and how much must they defer to the president in these deployments? Those are the basic issues. All of these courts are struggling with what are close cases because there's a little bit of disruption, a little bit of breakdown, a little bit of violence, not much. The president is wildly exaggerating what's going on. Anyway, that's the situation, and it's also, there's one of these cases, the Seventh Circuit case, is now being considered by the Supreme Court.
And Bob, you can weigh in on this, but and then I have an observation I'll throw into the mix as well.
Sure. So this is a point on which Jack and I have debated this back and forth a good bit. I'm of the view that the court in Portland was also of the view that what the president says matters, and that the reconstruction of the case in the court by the president's lawyers is all well and good, but the president has said certain things about the conditions that require him to assert this authority, and they're false. Right? Portland's not burning to the ground. It's not war-ravaged. Maybe not nobody has to defend, let's say, protesting out of hands or violence or anything that undermines the ability of the federal government to enforce the law. I mean, we have to defend that. But the president has made statements that warrant an extraordinary step. He's made it, by the way, in connection with other statements that he's made about the violence that he sees in Democrat cities, just as a class. And I think the courts need to take that into account. That's what he said, and it's not true. And if his lawyers can say something different, no, the lawyers will say something different. Although, by the way, I think I'm right about this, some of the factual submissions that they made in court have recently had to be rescinded.
That's
because
correct.
They're not correct.
Yeah.
So I think that affects deference. I think I can say, and it's a question I always ask myself, and I think Jack will vouch for me on this score, maybe not successfully ask myself, would my position be the same if it were a Democratic president? I mean, we have to always ask ourselves, what if the shoe was on the other foot? Are your political priors driving your conclusion? I don't think so. I think presidents, whether they say it in Truth Social or on X, or they say it in the East Wing, I was going to say the Rose Garden, doesn't exist anymore. If they say it from the Oval Office, that's the reason he gave the American public. It's a statement of his justification for exercising emergency power, and if it's false, and if the government itself has been unreliable in submitting factual representations to the court, I think that should shrink the zone of deference dramatically.
Okay, so Jack, do you have reservations about that, which I really take as an evidentiary point that might help illuminate whether or not the asserted statutory justification is legitimate or whether this exercise is politically motivated?
Well, it could be both politically motivated and legitimate.
Fair enough.
Legally legitimate. I mean, I actually, the way you stated it there, Bob, I don't have a terrible disagreement. If what we're saying is, if the case, the actual facts on the ground are really close, and it's not clear whether the statute is satisfied, and the president is saying crazy, exaggerated things, will the court take that into account, and should it? I don't have a problem with that. I don't think they can put it in the opinion, but I don't think this can become an operational legal principle. I mean, if there's serious violence in the streets of Portland that would justify federalizing the troops, and Trump exaggerates the levels of violence by 10 times, I don't think the court can say, sorry, Mr. President, the statute is clearly satisfied, there's clearly legal justification otherwise to use the federalized National Guard here, but because you on Truth Social said it was 10 times worse than it is, we're not going to allow you to do it. I just don't think that can be the operational principle. I'm not sure you disagree with that. And so, but I agree that in the very closest case on the merits, that the president's lies will certainly influence courts. I believe that.
And I'm not sure, I think we're close. I'm not quite sure we fully agree in one respect. I don't know, as a means of the courts holding the president's feet to the fire, that it is inappropriate for the courts to cite the representations they believe to be false.
Mm-hmm. But the problem is, if they cite the representations they needs to be false, then they've made it legally relevant, and then the hypotheticals start happening. Well, what if there's real violence, terrible violence, but the president exaggerated it by 2? And they're not going to be able to hold that line, I don't think. I think it's a dangerous line for the court to go down in making it overtly relevant, but we'll see what happens.
In her dissent in the Ninth Circuit case, Judge Graber explicitly referenced Trump's comments, and clearly that influenced her view of the facts. And whether or not there is the justification required to deploy the troops under this federal law, which is Section 12406, for those of you who are keeping score, can be a very fact-sensitive determination. Yep. So the facts do matter, but this is an instance where I think I do agree with Judge Graber in the Ninth Circuit, where she basically says, what are we talking about here? This is people in downtown Portland who are protesters wearing chicken suits and inflatable frog costumes. They're not interfering with...
There was much more going on in Portland than that. That's a terrible misconstruction of what was going on in Portland.
And I'm taking it from her. And she also said in the 4 days immediately preceding the invocation of presidential authority under this federal law, nothing happened.
But as the majority said, correctly in my view, she was looking at 4 days instead of what had happened over 4 months and what might happen in the future. And that was legally wrong. Okay. And that there was serious violence over the summer and there were threats outstanding. I'm not saying that the majority got it right, but that was the wrong window. And you can just focusing on those 4 days, I think, was legal error, as the majority said.
Do you agree with that, Bob? Should there be a temporal limitation on the ability of the president to satisfy the statutory elements here?
Well, I'm going to do something that lawyers sometimes do, and it's a bit cheap. I'm going to use a bad hypothetical to, in support of my point. I think that when we talk about holding the line, if presidents have that much flexibility to say, well, it's happened in the past and it could happen in the future, then I don't know when it is they couldn't declare an emergency. What's an emergency? If an emergency has passed, it passed 4 months before, and the streets are calm, and federal law enforcement and state law enforcement collectively are able to police the streets and protect against violence, then it's hard for me to understand what this emergency declaration amounts to. It also invites the possibility that the president could say, well, based on what happened, and this is a bad hypothetical, but based on what happened in Detroit 20 years ago, we know this is a combustible community, and therefore we have to, now I don't think it's likely that a court would accept the 20 years before analysis, but where does the line fall? If the president has that much flexibility in what is supposed to be an invocation of exceptional authority, and I think the more leeway the president has, the less exceptional the invocation of authority will be, and the more often presidents will do it.
So it seems like we do have a difference on this. How serious, I think, may be open to question, but there, and my concern, to use that hypo, I think it reinforces the point that to the extent administrations are permitted judicially to use this law, to me it seems there is a meaningful risk of allowing the suppression of political dissent. And that, to me, as a First Amendment lawyer, is always highly problematic. So,
There's a Supreme Court precedent, several of them, that say, it can be read to say that the trigger for this, for a related law, is entirely in the president's discretion. Mm-hmm. And
Insurrection Act?
No, in this statute. It's interpreting a predecessor of this. So what we're talking about here, I agree, this can get out of control, and the issue here is, there's no doubt, all the courts have said so, that the president gets significant discretion under this statute. If this were any president other than Trump, it would be no problem for, a court would clearly say that the shutdown of the ICE facility for 2 weeks in the summer, followed by sporadic violence going on subsequently, followed by what Trump claimed was a resource allocation problem, et cetera, et cetera, et cetera. I have no doubt that that would receive deference. And I think that's the right legal result. And so maybe this is a case where but the problem is you have to establish a legal principle that applies across administrations. And I just don't think, as I'm with the majority in thinking that the president is not limited to looking at the window on the day or the day before he determines that he's unable to enforce the law. I just don't think that will survive as the legal principle.
Okay, let me end the discussion on this particular topic by referring to an article that was published in The Atlantic about a week ago by none other than J. Michael Ludig. And to folks who may or may not be familiar with Judge Ludig, he was a federal court of appeals judge on the Fourth Circuit, extremely conservative judge, extremely well-respected judge, was talked about during certain administrations as a potential Supreme Court nominee. And he wrote that in his belief, President Trump has arrogated sufficient power through these federalized law enforcement deployments to interfere with the 2026 midterms. So I'm wondering, that's a fairly provocative statement, especially considering the source. So I'm interested to hear both of your reactions to that assessment.
Well, Bob and I have an article coming out that we've co-written, coming out next week in The Economist, that basically makes that argument. So I'm afraid we agree on this one.
Yeah.
Okay, well.
It's quite, I don't think I agree with the way Judge Ludig put it, but President Trump has not hidden the ball on, and Bob, you're more expert on this than I am, so you should correct me, but he's not hidden the ball on claiming that, first of all, he has an executive order that proclaims executive power to interfere in congressional elections where the president has no power. He's claimed this power. He's made clear that his intelligence agencies, the FBI and the Director of National Intelligence, are taking steps to investigate the 2026 election in advance. He's put election deniers in important, and that's a technical term, in important positions in the Department of Homeland Security and in the White House who are going to be monitoring these elections. And he's talked about using troops in connection with elections. So the writing is on the wall. I think it's something that is clear that it would be foolish not to take seriously the possibility that he's going to try, that he's considering something. Whether he'll do it, we can't know. Everything that Bob and I could think of along these lines was almost certainly illegal. Not all of it is subject to judicial review. So I think it's something that has to be taken seriously.
Okay, well, that is certainly an alarming diagnosis. Bob, do you care to add to that?
I agree with that. I mean, I think if he takes the actions that he's clearly taken, unapologetically, and when Jack refers to election deniers, of course, people schooled in the belief that not only have elections misfired, but they've misfired primarily against Republicans owed to rigging by Democrats who, as Trump has said, can't win unless they cheat. So when you have those kinds of statements together with these various appointments and the suggestion that he's going to invoke particular authorities to protect himself against his Democratic cheating, I mean, I don't think you're in any way exhibiting paranoia by taking it seriously. So I completely agree with
It has to be taken seriously.
It has to be taken very seriously.
Now, let me just say, I mean, I'm not yet in despair about this. I mean,
Right.
I think the courts will do their jobs. The question is whether election officials will, and Bob works on this issue weekly, whether election officials will, one question is whether election officials will do their jobs under what will be extraordinary political pressure.
Let's shift gears and move to the last item on the agenda before we open it up to questions from the audience. And this one involves President Trump's favorite word, tariffs. So there is a U.S. Supreme Court case that is scheduled to be argued on Wednesday of this week, as I understand it. And I gather that the issue, and I did read the parties' main briefs in the case today, so I have some understanding of this, although it's certainly not detailed. I'm sure your knowledge vastly exceeds my own on this issue. President Trump, as I understand it, has invoked the International Emergency Economic Powers Act, IEPA. Is it true that no president has ever relied on this statute before to impose tariffs?
Yes and no. It is true that no president has relied on this statute to impose tariffs. President Nixon relied on the exact words in the predecessor statute to this statute to impose tariffs. That reading of those exact words was upheld by what the then Court of Claims, I believe it was. And then the language was reaffirmed or was reenacted into IEPA, became the successor to this earlier statute. And I mean, so that gives the government lots of ammunition on the textual argument, in my opinion.
So I'm going to ask you, Jack, to, and again, trying not to get too legally technical or weedy, but let's walk through the textual arguments. And then, Bob, if you don't mind, I'll come back to you and ask for you to explain the interplay of the major questions doctrine in the case. So
it's very simple. IEPA says that the president, upon declaring an external a threat from abroad, has certain powers, and the main power in question is to regulate importation. And the Trump administration claims that regulation of importation of goods includes the authority to impose tariffs on those goods. And that's it. And there's a debate about whether regulate includes tariffs, which are a form of taxes. There are kind of precedents going both ways on that. I think the government has the better of the argument on that. But the important point is that in a completely different political context, a different court at a different time interpreted those words to include tariffs. That's why the government will claim that it's on strong ground, and I believe that on that point, I'm not saying they're going to win the case, but on that point, I do believe they're on strong ground.
okay. And how about the language in the law that requires an unusual and extraordinary threat to U.S. national security? Because it seems to me we've had persistent trade deficits in the country for 50 years. Why has this all of a sudden become so particularly acute that we need this emergency presidential authorization?
Well, I mean, it's the president's call about that, and I can assure you that there have been many, many dozens of invocations of IEPA by past presidents that for things that were far short of this threat. And the fact that other presidents haven't seen fit to use it, I don't think is terribly probative here. And the president gets a lot of deference on that question. I'm confident that the court will not, it might well strike down the president's tariffs, but I'm confident it won't be on that ground. I'm pretty confident it won't be on that ground.
Okay, what is the major questions doctrine, Bob, and how does it play into this?
Well, it plays into it as a doctrine that basically, and Jack will I'm sure encourage me to be a little more precise about this, but that where an action is one that has just, enormous impact, that it will not be assumed, absent clear congressional language to that effect, clear congressional intent to that effect, that Congress intended to authorize the president to do it. And these tariffs, this tariff power is, of course, arguably, I don't know, actually, Jack, I don't know if we've discussed where you think that is. I think you're going to express an opinion about whether you think the court will go in that direction on this, correct?
A major question.
Yeah, major question.
Yeah, my last question is I'm going to put both of you on the spot, is how this case is going to come out.
Yeah, so, but again, this reminds me a little bit of the debate, if I may go in this direction again, and reminds me a little bit of the argument we just had, or the discussion we just had about the deployment of troops. It seems like it's impossible to imagine that Congress ever intended, regardless of some of, and I think Jack correctly states, the textual arguments that can be made in the president's favor here. I don't know that I'm persuaded that they're as strong as Jack suggested, but there are arguments that can be made, and they're not frivolous arguments that can be made. But it's impossible to imagine that what we've seen the president do with tariff power is something Congress ever intended to authorize. It has included not just constant moving of the tariff schedules back and forth, depending, frankly, sometimes on whim, less on clearly articulated policy, but it has included, for example, expressing anger with the country of Brazil about how they've treated a former president under investigation, incidentally, for election fraud. It has included recently throwing another 10%, another 10% on top of the tariffs levied against Canada because Ontario ran an advertisement against his invocation of tariffs that he didn't like, even though it accurately depicted what Ronald Reagan had said years ago about the tariff power and its dangers. It's just impossible for me to imagine that the court is going to think, yes, we can endorse this particular regime of presidential tariff levying power, but how it gets there and how it specifically deals with the potential consequences that the administration is very darkly depicting of ruling against the president on the tariff power after the government has already collected billions of dollars under tariffs that may have been illegally imposed. I don't have a crystal ball on that.
Yep.
I think we've had some intimations of how you think the court is going to rule. But to be clear, Jack, what do you think
that the government has the better of the legal arguments.
Okay.
But I kind of agree with Bob that, well, it's just, I don't think the legal arguments are going to resolve the case. I kind of agree with Bob that even if they win on the law technically, that this use of IEPA is certainly unanticipated, even if it's justified on a textualist reading. The implications for what the president might do under IEPA are so sweeping and enormous, and President Trump has exercised his power in such a, just to call it mercurial is to be an understatement, that I don't know if he's going to have 5 votes. I think he'll either lose or they'll split the baby in some way.
They'll be what, pardon?
Split the baby. There are 2 different types of tariffs. There are the tariffs to deal with drugs coming over the border, and then there are the tariffs to deal with the trade deficits, and I can imagine them somehow coming up with an argument to distinguish those so it won't seem like a total loss for the president. I think the administration hurt themselves badly before the court. This is not a legal point, but there was some discussion 2 weeks ago where the administration said, well, even if they strike it down, we've still got other authorities under which we can issue these tariffs. That makes it a lot easier for the court to do it. Yeah. The tricky part, and the last thing I'll say is, a lot of money has been collected under these tariffs, and there's a very tricky question about, does that money have to be reimbursed? If so, what will that do to the economy? The Trump administration is really raising the temperature on the court by saying basically that it would destroy the economy if they reverse and order the return of those monies, and that will certainly give the court pause. But the opposite decision will also give the court pause. I think it's one of the hardest cases in many, many years.
Yeah, this is one of those opinions I can't wait to read. I think it's going to be fractured, certainly, so we'll have to probably wait until the end of next June. So we're at the time for student questions and answers or any members of the audience.
Thank you very much for the discussion. I just wanted to ask a question about weaponization against one of the entities you mentioned, that's universities. So we're at a college right now, you're professors, so you, I'm assuming, have opinions on this. And even the previous president of Hamilton College has written about this, and that's that specifically, for example, entities like Harvard University can't win against the president even if they win in the courts, especially because you can't sue the government for punitive damages. So from the perspective of someone who wants to go into academia, that almost seems like a loophole, or at least a terrifying prospect that the government can interfere and never seemingly receive some repercussions on it. So is that something that needs to be changed, or is this something, another norm violation as you mentioned it from before?
So my view is that I can speak to the Harvard case. My view is that what the president is doing is clearly unlawful in terms of, I mean, first of all, there are so many investigations going on, but in terms of the funding cutoff, they've done it in a way, a sloppy way that's clearly unlawful, and Harvard's been winning in court. But I think that Harvard will win the legal battle but lose the political war. And, you know, they can win this case, but in future years, the funding likely, almost certainly won't be there. And, I mean, my thoughts on this are too, it would take me too long to explain them. But I'll just say that Harvard is, the entire university is deeply dependent on federal money. And we're learning that deep dependence on federal money, especially when you're at an institution, and certainly in the college and other parts of the university that are very, very, very left, that it's a dangerous thing to do when you take a lot of money from the federal government and you're a very left institution in many of your operations and attitudes and hiring and the like, and a conservative administration comes into power. So, I mean, that's the way I see it.
Bob, you want to add to that?
No, I
No?
agree with that.
Okay. Next question? I think there's one in the back.
The federal government has been intervening in a lot of economic activities as of late, including the administration's purchase of 10% of Intel. What are your thoughts on the consequences of these increased federal interventions in private entities?
It's deeply ironic that a Republican and supposedly conservative administration is taking ownership in private entities and is insisting to take a piece of profits. And the whole thing is bizarre from the perspective of political philosophy. And not a peep out of Republicans. Their heads would be exploding if any Democratic president even talked about this, much less did it. So that's my first point. The second point is, I don't understand, my natural inclination is to think it's not a good idea, but I'm not versed enough to know. Third thing I'll say is, I actually tried to figure out, and I'm still trying to figure out how exactly it is legally that the government took 10% of Intel. And I've done a moderately deep dive on this, and it's not at all clear to me that they did it by lawful means. So that's all I'll say. I mean, it's so, I'm not expert enough to know what the legal political implications are. It's certainly not the way I view the world as it should run, and not the way that conservatives traditionally view the world as it should run. But this is not a conservative administration.
Bob, thoughts?
Yeah, I would stress that point many, many times over. As I said it at the beginning in connection with another point we were discussing, this isn't a conservative administration. It's a very different Republican Party under his leadership than any that I'm familiar with from past years. And again, we've been talking about what Donald Trump brings to the presidency as somebody who's only run for 3 federal offices, did so very late in life, and had said in 2016, memorably, that he thought the country would be better off if he ran it the way he ran the Trump Organization. And that's just such a rich statement in many ways But one thing this reflects is not some deep new governance model. It's Donald Trump's belief that it's a great deal. He got 10% out of that deal.
Right.
That's how he thinks about it.
Right.
I mean,
And may have gotten some on the side, as is happening in other contexts.
and who knows who made some money on the side. And I think that's a worldview that he brought late in life to this new career in politics. And does it establish a model that other future presidents will want to emulate in some way? I mean, I would hope not, but I think we have to look at it in those terms.
Hi, thank you so much for having this discussion today. You mentioned the fragility of our elections, especially when it comes to 2026, and I was just curious if you thought that we've kind of passed the point of no return after 2020 and all of the legal challenges that the election results went through after Trump lost. I think that we were very lucky that Trump won the popular vote as well in 2024 because even coming from someone who sees a lot of more left-wing media content, there are some people even throwing around claims from the left that the election was stolen back in 2024. And so seeing that similar claims are coming from both sides, I'm starting to doubt if we've have such significant erosion of trust in election results that we've kind of passed the point of no return.
But yeah, Bob, why don't you tackle that one?
Yeah,
As the election lawyer.
I lost the last sentence about past the point of no return in what respect?
Because we've lost trust, lost so much trust in elections.
Oh, yes, yeah. We're dangerously close. I don't know that we've reached the point of no return. I spend a lot of time talking to election officials around the country in a nonprofit pursuit that's related to my career interests and my academic interests. And I speak to both Democratic and Republican election officials, and at this local level, we have a very, very decentralized election systems. They generally command the trust of their own voters. Those voters may, for example, be very comfortable with the way that elections are run in York County, which is a Republican county in Pennsylvania, but be convinced that elections are being cheated or being rigged in Philadelphia. So there's multiple levels to the loss of confidence here, but it's not pervasive. It doesn't occur in every community as it affects the elections that they, the citizen critics, are involved in. But it is a fragile system. We don't spend money on our elections nearly to the degree that we need to have them operate the way that they should operate. They are a low budget priority at the state and local level. The machinery that we use is outdated. There's not even an adequate market for machine innovation and replacement. The poll workers that we have working the polls are paid very little per day for the most part, and they have to volunteer for duty, and then they essentially get per diems. Many of them are very old, and it's very difficult to train them, not because they're old, but because they just show up once a year to do this work, which is commendable, but those are very long days, and they're put under a lot of stress. And there are any number of things that I can relate to you that make this election system in the United States surprisingly underdeveloped and under-innovated, and yet the officials do a remarkable job across the board making it work. So that's one thing I just want to stress. It's fragile, and therefore this political pressure that's being put on the elections can be very destabilizing because they have that kind of that fundamental structural weakness. As to the second point of, what's the point of attack here? We've seen a steady increase in election denialism over a number of decades. And now it's, as we've discussed over the course of the evening, it's gone into a completely different dimension under Trump. His position being, repeated over a number of years, that he will never lose an election unless the Democrats are cheating. And the Democrats cheat, said it recently in the last 3 months, Democrats cheat all the time. And the effect of a major political party and its president of repeatedly communicating to the American public that they can't trust the electoral process because it's rife with fraud, and the opposition party routinely cheat, the effect of that cannot be underestimated. So that combination of an attack on the system like this, coupled with the basic fragility of the system, I think is a source of really, really significant concern.
Could you say a few words about the law that underlies the current operations in the Caribbean and in the Eastern Pacific? I spent 30 years in the military, and this violates just about everything I ever learned about the law of armed conflict.
Yes, I can speak to that. So I agree with you about the law of armed conflict, and I'll get to that in a moment. So there are two questions. These are the Venezuelan and other boat strikes in the Caribbean, and then boat strikes in the Pacific as well. Just as a factual matter, it's very hard to imagine that where some of these boats are being destroyed, that these boats are actually capable of bringing drugs on these boats to the United States. There's lots of reasons to believe that the factual premise for these strikes is at least questionable. But set that aside. There is because the Justice Department and because the presidents have asserted such broad authority to use force, and because there are an array of Justice Department opinions, there's a colorable argument that the president has the power under domestic law, under Article 2, to use force in this way, as crazy as that seems. But you mentioned the law of armed conflict, which is an international law, and basically you're not allowed to, under international law, kill civilians. You can, and it's murder if you kill civilians. One of the reasons you're able to kill during war is because it's a special status. You're in an armed conflict, and there are special rules when you're in an armed conflict that go along with about who you're allowed to target, how you're allowed to target them, et cetera, et cetera. This is what distinguishes killing on the battlefield from murder. But the trigger before you get to this is what you call armed conflict. And there's no conceivable argument that there's an armed conflict between the United States and these alleged drug runners. There's just no conceivable argument, which means pretty clearly that the DOD is involved in my judgment, in murder. And the reason, and I think this is what you were talking about, the reason this is a big deal is because the Defense Department has, I'm very surprised from this from a cultural perspective. I used to work in the Defense Department, and this might surprise you, but there's a very powerful norm in the Defense Department of taking the law of armed conflict very seriously, and for having an international justification for using force. And it's something they take very, very seriously. I'll add that one of the first things President Trump did, or Secretary Hegseth did, was fire all the top JAGs, the Judge Advocates General. And there are legal consequences under the war crime statute, under the UCMJ. So I think what you said is right. It's clearly illegal under international law. I'm confident this is culturally wrenching at some levels of the Defense Department. It may have been why the head of Southcom resigned. We don't know. But the remarkable thing is that, very few people seem to care. At least, I'm sure a lot of people care in DOD, but in the public. Does that answer your question?
I think we have one more question up front.
My question is, what do you think can be done? Right, you've outlined several aspects of how the current administration has weaponized the presidency, and so my question for you is what you think can be done?
To stop the weaponized presidency?
Yes.
Yes. Do you want to go first? You want me to go first? I think you should go first on this.
All right, I'll go right. There are things that could be done. First of all, I think
That wouldn't have been my answer, so I'm glad you went first.
yeah, we have a sort of an association that includes different temperaments. Jack tends to be pessimistic. I tend to be optimistic. Unfortunately, he seems to be right a lot of the time. But nonetheless, the presidency does have to be reconceived, and there's a long-term, it's not going to happen in my lifetime, constitutional reconstruction that's going to be necessary. It just doesn't work anymore. This constitutional order under which we're currently operating under is frayed to the snapping point. And so there's going to have to be a reconstruction at some point. That's a big piece of business, and it doesn't happen very often in our history, but there are statutory reforms that are possible that could make a difference. It is very difficult to attack, for example, the norm that is supposed to separate the president from control of the Department of Justice. It's very difficult to legislate that back into existence. But there are steps that you can take to clarify the application of the president's conduct under the obstruction of justice laws. There are steps that you can take to deprive the president of some of the means of self-protection, for example, the exercise of the pardon power. Some part of that's constitutional, some part of that could also be statutory. So there is a program you could cobble together that's a realistic program that wouldn't require calling in a constitutional convention. And we cover a decent amount of that in our book, and some of that we would retain today, and some of it we would decide, we'd set aside and maybe focus on other things. So I think that could happen, but I don't know when and under what conditions.
So I'll just kind of say one thing quickly. In the
Sure.
shorter term, there are only 2 or 3 things that could happen. One, I do think the courts will not say yes to everything the president's being done. We have a lot of important decisions this term. I think the courts will say no to more than one of these important assertions of presidential power, and I believe the president will abide by those decisions. But other than that, and other than changes in politics, which could only come from, I think, a much worse situation than we're in now in terms of the politics around Trump collapsing, I think the only other solution in the short term is elections. And we're very early in the Trump administration. We're not even finished with year 1. So I'm afraid I don't think that there's much that can be done in the short term other than the courts. And Trump does respond to politics when they turn sharply against him. And it's, we'll see if that happens. But other than that, there aren't a lot of tools right now because Congress is on its back, as we've been discussing.
Okay, we're just about at time, so I'd like to ask Bob first and then Jack second, just to provide some concluding observations, comments, thoughts. They don't necessarily have to be tethered to a specific topic we've spoken about tonight. And then after that, I'll say a little something to close things out.
Look, I think that there is a basis that has to be rescued from the polarized politics of the time for some bipartisan recognition that the current state of affairs, whether you're a Republican or a Democrat, is not sustainable because, as we all know, a presidency that's structured this way and that appears to be successful in achieving many of its aims is a presidency that is going to be very attractive to at least some on the other side. We're just going to be either in a cycle of revenge, that doesn't work out for anybody, or alternatively, there will be a Democratic/left populist presidency that may not do everything that Donald Trump does, may not be so obsessed with revenge, but will push presidential powers aggressively also on the grounds that we have our own program to implement. We ought to implement them with at least the same zeal with which President Trump implemented his. And I think that I do believe that there are limits, but those limits are going to have to be crafted. It cannot be crafted by one party alone in opposition. There just has to be a coalition that involves independents and Democrats and Republicans who, whatever their disagreements on policy, recognize that at least this is not something that we can tolerate over the long term.
Jack?
I'll say one pessimistic and one somewhat less pessimistic thing. The pessimistic thing is we haven't really talked about what's at the foundation of all of the things we've been talking about, and that is that the American people are deeply divided in ways that have never been true in my lifetime. There have been precedents in American history, but the reason that Congress is the way it is, the reason norms are collapsing at the presidential level and the congressional level are in some sense reflective of what's happening in the country. And all of these things, I think, will rise or fall together and need to be fixed together, and I don't have a great solution for that. The less pessimistic thing I'll say is I'm still hopeful, and I'm even still hopeful that things aren't going to go terribly bad under the Trump administration. It's still early. The truth is that most of what Trump has done has been negative and destructive of the government, but the affirmative program has not been terribly robust or successful because they're still not terribly competent in governance. The Supreme Court really hasn't weighed in yet. It remains to be seen how much of what Trump is doing they will allow. And so I think that we have, we have 3 years and 3 months left of this administration, and it could get worse, and it might well get worse, but it might not get worse. And so I'm hopeful that it won't get worse.
The last point, and I know we're at time for whom the bell tolls, but if it struck me in reading Judge Graber's dissenting opinion in the Ninth Circuit case that we spoke about previously, her last paragraph, she's clearly aware of the significance of this issue and that she's writing for history. So she ends with the last statement of her opinion by saying, and I'm trying to strike an optimistic note as well in quoting her, "Above all, I ask those who are watching this case unfold to retain faith in our judicial system for just a little longer." And I take it that what she's saying here is implicitly recognizing that the Article 1 branch of government has abdicated its function in checking the president. Congress isn't going to do anything. But folks, stick with us. Stick with the judiciary. We're going to do our job. We took an oath when we were sworn into office and accepted our commission. And by and large, I think the lower federal courts have done a very good job of applying the law in the cases that involve some of the overreach of the Trump administration. So let's hope that that continues. I think in some ways they have not gotten appropriate guidance from the US Supreme Court on some of these questions because of the prevalence of issues that have hit the shadow docket and have been decided without clear reasoning or instruction to lower district courts. But I do think the federal judiciary is taking its job very seriously and is perhaps the last bulwark that we can rely on here. So before we thank our speakers, is Kim Ritchie here and Katie Stewart? Are they in the room? So thanks to both of you for all of the work you do in making this program possible. We are all your beneficiaries. Ty Sedgley, as usual, thanks for the opportunity to participate. I hope everyone will join me in giving a warm round of applause to our guests, Jack Goldsmith and Bob Bauer.